All right, we are now on to Chapter 3 for this class recording. Let's start out with the Black's Law Dictionary as to what the definition of law is, which is that which is laid down, ordained, or established. So generally the law could consist of a culture's moral code, the commandments of a religion, and the regulation enacted by a political body. So, with the American criminal justice system, we are still talking about the three prongs of the American criminal justice system, but we are talking about the cops, the courts, and the correctional system. All right, so law defines a rule of conduct or procedure established by custom, agreement, or authority. So, examples would be that we marry one person in society, so that is a custom. And I've kind of color coded this, as you can see. So the green is the custom, the blue is the agreement, and then the gold is the authority. So two, most states recognize each other's driver's licenses, which that is an agreement, and we must have a driver's license to operate a vehicle on the road, and that is authority. All right, so let's look at back historically. Where do we get our origination of ancient laws? So the first known written laws were actually found on clay tablets in Uruk in the Sumeria over 5,000 years ago. And the king Hammurabi ruled in Babylonia from 1792 to 1750 and developed the Code of Hammurabi, which consisted of 282 laws that dealt with marriage, divorce, debt, wages, and slavery. You can see a picture of it on the right there. And the laws were carved on an 8-foot monument. Then we have the emergence of English and American common law. So every ancient nation developed actually what we have called formal legal codes. And our American legal system derives primarily from that of England. So before the Norman conquest, the church in England played a major role in administering the law. We have William the Conqueror established a court with judges who traveled throughout the kingdom once every 7 years to hear cases as representative of the king. Then we have common law. So the decisions of the traveling judges formed a large part of the England's common law. And common law is law that is created by judicial opinion, which has set precedents that are still followed today. And common law was developed through interpretations and elaborations of the concept of violence until crimes were recognized, such as homicide, robbery, arson, and assault. And in the 16th century, Parliament began adding specific crimes, so more crimes other than the ones above, to the common law offenses. And then we have what we call the emergence of modern criminal law. And upon the establishment of the 13 original colonies, they adopted England's common law. As the county developed, the laws of the U.S. developed separately from England, and eventually statutory law replaced common law as it was developed by the legislatures of the state and federal governments. And then we have statutory criminal law. So all 50 states and the federal government have their own separate set of criminal statutes, kind of like we talked about in Chapter 2 last week. So no state is bound by the criminal laws of another state. And federal criminal law has expanded to situations where federal jurisdiction does extend over all criminal states. Now we have the growth of federal criminal law. Prior to the Civil War, there was very little federal criminal law. Punishment was left mostly to the states. And then since the Civil War, Congress has enacted laws from civil rights, use of the mail, commerce, narcotics extortion, interstate travel for illegal activities, and organized crime. So you're going to see this again in your quizzes, so make sure you note this page to remember sources of American law. And so sources of our law, we get them from one, constitutional law. And as I remember, you'll kind of see this from matching. So I wouldn't say you have to memorize this, but make sure you keep this so that when you see it on the quiz, you can refer back to this. We get it from statutory law, 3, administrative law, and 4, case law and common law. So make sure you pause here and read through this so you're familiar where we get our sources of American law. All right, we also have conflict of law. So citizens look at religious and moral values, and they also look at rules created by the government. So citizens disagree with what behavior should be regulated by the government. For instance, abortion. Some say it's the same as murder, and others say it's not murder. Physician-assisted suicide. Some agree and disagree. Some states say it's legal, others say it's not. And then we have the use of reproductive technology and CRISPR technology. We have gambling, prostitution, drug use. Some states have marijuana legal. Federally, it's illegal. Criminal cases are prosecuted by public prosecutors. The chief public prosecutor in a federal criminal case is called the U.S. Attorney. Hint, hint, you're going to see that again on a quiz. Most trials are conducted by the assistant U.S. attorneys. Some court-appointed defense lawyers work for organizations funded by the states and are called public defenders. So, for example, in your larger jurisdictions, you will actually have your counties that have public defender offices that will work out of the county. So if you are arrested and you cannot afford your own attorney, your own public defender, it will be you will be given your own public defender from the public defender's office. Other jurisdictions, like locally, they're not big enough. It's not a big enough jurisdiction to have a public defender's office where you have full-time public defenders working in an office full-time. So what will happen is your criminal defenders that work locally will be assigned cases that they work, and they'll be paid for by the court. They're just local criminal attorneys that normally work on private cases, and they'll just, whenever somebody needs an attorney because they can't pay for one, they will be assigned an attorney that's just a local attorney. So you're getting a really good attorney. You're just getting assigned one because they don't have a local public attorney defender's office because it's not a big enough jurisdiction. All right, you want to know this as well because you're going to see, I'm going to ask you questions on quizzes, and you need to understand the difference between criminal law and civil law. And I think we're going to see this in some other slides, so I'm going to explain this various times, but you need to know the difference between criminal law and civil law. And one of the ways that I explain this, and it helps me visualize it as well, is looking at the O.J. Simpson case, because a lot of people remember this. There's been a lot of documentation in the media on it. There's also been movies done on it. There's been documentaries on it, and so people understand it. So O.J. Simpson was tried in criminal law for the murder of his ex-wife, Nicole Brown Simpson, and her boyfriend, their murders, so 2 different murders. And so in a criminal court, the burden of proof for a jury or a judge, depending if it's jury trial or judge trial, is what we call beyond a reasonable doubt. So the evidence at trial has to be beyond a reasonable doubt. Now, it doesn't mean you have to have video proof, but it really has to tip those scales that the defense, that the person on trial for the crime is proven guilty beyond a reasonable doubt. Okay? Well, O.J. Simpson, if you remember, was found not guilty. The jury said, we can't prove beyond a reasonable doubt that O.J. Simpson in a criminal court of law is guilty. However, in a civil court of law. Now, in a criminal court, if you remember, if somebody is found guilty, they are sentenced for a felony to prison. So all their rights are taken away. They are sentenced to prison. They lose their freedom. So what happened was his ex-wife's Ronald, that was murdered, Nicole Brown Simpson's, Ronald Perlman's family sued O.J. Simpson in civil court. And the burden of proof in civil court is very different. It is not beyond a reasonable doubt. It's what we call preponderance of the evidence. So if you look at a scale, and they call the scales of justice, it's not really tipping it beyond a reasonable doubt. It's what we call preponderance of the evidence. So it's just tipping it a little more than not. So it's just kind of that 51%. It's not equal, so it's not 50-50. It's just a little more than not. So when they tried the case and said, hey, we think O.J. Simpson killed Nicole Brown and Ronald J. Perlman, we think O.J. killed him, and they showed all the jurors all the evidence. Like I said, it's different in civil case. It wasn't beyond a reasonable doubt. It was just preponderance of the evidence. They just had to, like I said, tip the scales just kind of over that 51%, and he was found guilty. Now, because it's not criminal, he wasn't facing, O.J. Simpson was not facing prison. He was just facing what we call money. So fines. So he just owed money if he was found guilty. So that is your main differences in burden of proof. And that is your main differences in what happens if found guilty. So make sure you understand the burden of proof as far as criminal, burden of proof beyond a reasonable doubt for criminal case, and preponderance of evidence for a civil case, and going to prison if found guilty in a criminal case, and a monetary fine in a civil case. All right. So again, civil law deals with matters that are considered to be private between individuals, personal injury contracts, property law. So for example, another example of civil law would be a lot of times landlord-tenant laws. I would get called out when I was an officer, and people would say, my landlord just locked me out. And I would say, first of all, I don't want somebody to be locked out in the cold. So I would say, well, first of all, this is civil. And I would tell the landlord, this is a landlord-tenant case. You want to go to landlord-tenant civil law. This goes in front of a judge. You don't want to do anything wrong and be held liable. You don't want to lock somebody out. It's not a police matter. And they say, well, my landlord raised my rent. Can you make them not do that? And again, it's not a legal issue as far as for the cops to handle. It's civil law. It's not a criminal matter. It's a civil law. So a lot of things out there, cops can be there to keep the peace, but they're not criminal in nature. They're civil in nature. All right. So remember how we just talked about levels of proof required. So if you look right there, remember I said if you look at those stairs, if you look at the top stairs, beyond a reasonable doubt. So the criminal case, that's where beyond a reasonable doubt is. That's a criminal case. That's where somebody in a jury trial going away to prison, before they go away to prison, that's what somebody has to be found guilty of, is beyond a reasonable doubt. If you see the preponderance kind of at the middle of those steps, that's in a civil case. That's a preponderance of the evidence. We're also going to be talking about, coming up, the Fourth Amendment, and we're going to be talking about the search and seizure. And when we get to the American criminal justice system prong of cops, we're going to be talking about reasonable suspicion and probable cause. And those are those bottom two steps. So all these are really important. In fact, keep this slide, keep a picture of it, print it out, or write it out, because this is really an important slide that you're going to need. You're going to see it on quizzes. We're going to be talking about this, and you're going to need to understand this. So real important slide right here. All right. Also right here, this is just an important slide to understand when it's an issue under civil law and under criminal law, to understand when it's, for example, an area of concern is under civil law, when it's between individuals, and under criminal law, when it's important. So this is really important to, I've just talked about it on the other slide, but to really pause here and make sure you read through these and really go through them and understand them. All right, so to be convicted of a crime, two elements must exist. And again, you're going to see these on the quiz. First is the criminal act, which we call the actus reus. So that's the guilty act. We also you have to have a state of mind, which is the mens reus. So that's the wrongful mental state. So what constitutes the wrongful mental state varies according to the action. So this is an important slide to understand as well. So sometimes I will have students in class read through this a couple times because, again, you're going to see this on a quiz, and I want to make sure you really understand this. So the corpus delicti is the starting point. So, for example, it's the body of the crime. It's the proof that the actual crime has been committed. You'll see this a lot of times on movies, and they get it right. If there's no body, then you don't have proof that a crime's been committed. So example one is in a murder, the body is the corpus delicti. And example two is in a bicycle theft. The bicycle being gone is proof that a theft occurred. Okay, so actus reus, it's the guilty act. So the guilty act must be voluntary. So example one, in a murder, the actus reus is the homicide. Example two, if a vehicle is stolen, the actus reus is motor vehicle theft. So commission is the movement, verbal possession, and the omission is the failure to act when had a legal duty to do so. Your mens rea, or your state of mind, is your intent. So person must intentionally, knowingly, and willingly commit the criminal act. So example one, the homicide, the person committing the homicide must understand that it is wrong and is a crime. So again, this is where we will be talking about in the future weeks insanity. This is where you have to understand that it's a crime. Otherwise, you can plead that you're insane. And this is where we get what we call the reasonable man test. And this is kind of our line test where you have lowest to highest of general negligence, then we go to recklessness, general intent, specific malice, and then premeditation. All right, mens rea, state of mind, we have insanity, which means lacks the capacity to appreciate the wrongfulness of their conduct and under the influence of alcohol. Voluntariness is the key. So, insanity. We have what we call the Macnaghten Rule. So in 1843, Daniel Macnaghten, he was a deluded Scotsman that thought the Prime Minister, Sir Robert Peel, and he's a really important guy because he really is the guy who started modern professionalism in policing. We learned about him and talk about him in Introduction to Policing. But anyway, he thought the Prime Minister, Sir Robert Peel, was persecuting him, basically tried to shoot him, and instead killed his secretary. And Daniel Macnaghten was ruled insane and spent 20 years in a mental asylum until his death. The Macnaghten Rule is to establish a defense on the grounds of insanity. And it must be clearly proved that at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the acts he was doing, or if he did know it, that he did not know that what he was doing was wrong. All right, here's a quick map that you can pause here and kind of look at it color-coded of all the states to look at which states have no insanity offense, which have the Macnaghten Rule, and how they're kind of aligned. And then here's kind of a look as well that you can pause to look at which state, which have justification and excuse defenses and how those are aligned. And then we're going back to the reasonable man test is an individual is not liable in a criminal court for remote, unforeseeable, or indirect consequences which a reasonable person would not have foreseen as likely to have followed from the act. There is a liability for the direct results of the act, but a diminished no criminal liability for remote, unforeseeable, or indirect consequences. And we're back to mal in se, considered wrong, even if there's not a law that prohibits it, so it's inherently wrong. Natural and moral law, example, murder and mala prohibita, considered a crime because it has been defined that way, put into statute or law. And it does vary from place to place, states, countries, localities, example, gambling. All right. Criminal homicide. So it's homicide that was neither justifiable nor excusable. This is examples are first degree murder with premeditation, second degree murder with malice, voluntary manslaughter with general intent, involuntary manslaughter with recklessness, and statutory manslaughter with general negligence. All right, we also have the felony murder rule, which is any death which occurs during the commission of a felony can be considered murder. That's usually first degree murder, where all participants in the felony or attempted felony can be so charged, as long as there's some type of causal connection between the felony and the killing. So this rule does broaden the crime of murder in two ways, even if there was no intent to kill, if a death occurs during the commission or attempted commission of a felony. Murder can be charged as long as there is a causal connection between the felony and the killing. And all participants in the felony can be held equally culpable, including those who did the harm, possessed no weapon, and did not intend to hurt anyone. We also have what's called the statute of limitations. So this means if you commit a crime, you have to be charged with it within a certain amount of time. And this is because what they say is, hey, if I commit a crime, and somebody waits 20 years to charge me with that crime, it's not fair to go after convicting me, because people forget about things, and it's just not fair. So the length of time does vary from state to state. Misdemeanors, it's usually between 1 and 3 years. Murder does have no statute of limitations. So if I murder someone, it doesn't matter how long it's been, the state can still go after me. Other felonies, it's 3 to 5 to 7 years. Sexual assault, it generally depends on the state and different things. So now let's look at what happens if a person's arrested. All right, so, and this is where I bring in kind of a color-coded what we call COPS of the 3 C's. So this is where we bring in the American criminal justice system, the COPS, the courts, and the corrections. So this is what happens prior to the prosecution, okay? So arrest and booking, detention is not an arrest. So we have probable cause, which means a crime has been committed, the individual committed the crime. We have warrants, arrest warrants, search warrants, and when a warrant is not needed. So we're going to be looking at that. So criminal procedures prior to prosecution. So we have an investigation after the arrest. Someone is arrested, and we want to investigate. We want to find and interview witnesses. We want to conduct searches. We have witnesses. We want to interview. We may decide to change the offense, because we may say, hey, we're starting to interview witnesses and find out that what we originally charged the suspect with, it's not right. We want to change that. We may release the suspect with a warning or referral to a social service agency, because rehabilitation is more appropriate. So this was kind of the COPS. This is where the COPS were doing the work. That's why we had the blue. Now we're going to move on to the courts. So now it's the prosecution begins. So now the prosecutors have broad discretion. They're going to decide if they want to pursue the case. They're going to decide, hey, what should we do? They're going to decide, hey, should we pursue the case or should we not? Is there going to be a conviction? What's the evidence? Should we formally charge or shouldn't we? It's still with the court. See, we're still with the courts. This is where the complaint is a statement of charges. This is where the suspect makes an initial appearance and the defendant's taken before the judge. This is where the bail is determined by the judge and the defendant pays the bail, or gets a bail bondsman and pays 10% of the bail. Okay, we're still with the court. So of the 3 C's, this is where a preliminary hearing is determined, if there's enough probable cause. We're still with the courts. This is where we have a grand jury review where they look at the probable cause. Hey, is there enough evidence? This is where an indictment's made. This is where we have an arraignment. We're going to be going over this still. This is where the suspect comes back and says whether they're guilty, not guilty. This is where they make a plea bargain if they want with the prosecution. We're still with the court. This is where we have a pretrial motion. This is where they look at all the evidence and the defense can make a pretrial motion to change venue, to sever, to do all those motions. We're still with the court. This is where they do discovery. This is where they hand over all the evidence. This is where they're getting ready for trial. We're still with the courts, and this is where they say, hey, we want to go to trial. And they're really looking at guilt or innocence, and they're looking at going to trial. Okay, we're still with courts. We're still looking at the presumption of innocence. We're still looking at the right to speedy trial. We're still looking at going to court. Okay, now we're at sentencing. Okay, so we're looking at incarceration. We're looking at sentencing. We're looking at the person was found guilty. We're looking at the jury. We're looking at penalties, all that kind of stuff. All right. So now we're leaving the courts and we're going into the corrections. So we left the cops a while ago. We've been at the courts for a while. We're entering corrections at diversion and at the appeal process. All right, so that was kind of a quick look into the three C's of the American criminal justice system. We're going to get much more into that, and this is going to end this chapter of the American criminal justice system, and we'll see you for the next video.